So I just got back from lunch. I've made it a habit lately
Hmm.
when I can to get away from here for an hour or so, just to go home and decompress a little bit. The work that we do, I think that would be an understatement if we said it was stressful, right? I mean, it gets up there because we're
Oh yeah.
carrying on our shoulders all of our clients' stress and problems.
Right.
And I think, over the years, it could take its toll. I certainly hope that it's not going to shorten my life or anything, but what I'm trying to do is some preventive stuff. So I went home, exercised a little bit, sat in the backyard, ate a sandwich. I'm back, feel energized.
That
Uh,
sounds nice.
yeah, it wasn't, especially on a day like today. People say that other states are greater because there's more green.
Yeah.
Well, as I was sitting in my backyard, I said, "But we've got more blue." We
That's
got the
right.
sky, man.
That's
Almost
right.
all year round, and I loved it, man. And it's the weather right now is just a tad bit chilly, and that's just perfect for being outside.
I heard it's the official start of spring, the meteoric spring. So
Feels like it.
yeah, and we're getting out of the winter. We're getting out of the cold weather. Although we had a little burst of rain yesterday,
Yeah.
which was kind of nice.
Kind of
Um,
sad because we need the rain. We really do need it. But then again, with COVID,
yep.
maybe somebody up above is giving us a little bit of a break and saying, enjoy the outdoors as long
Yeah.
as you're safe.
Exactly. Exactly.
Speaking of safe, as I was driving down Cordova, coming into our complex here, I saw two people walking without their masks on.
Oh my goodness.
Yeah, and they look like they were kind of some rough characters,
Right.
But it's way too early for people to be doing that. Without a doubt, it feels again like everybody's open for business. The cars are
Right.
pretty busy. It's not as insane as it used to be because there's probably more of us that are working at home and everything. But I looked at those guys and I thought, I wonder if the police stopped them. If I were still a cop, one of the things that I would want to know is who's not wearing their mask, because in my experience, the people that are like they have warrants, the ones that are on the lam for one thing or another, folks that just can't care for themselves, so if they take advantage of others,
Right.
how likely are they going to always wear their masks? It's almost like a look at me sign.
Right.
You know what I mean? And you get stopped. And I wonder, I also wonder if if cops could stop you based on not wearing a mask because it's pursuant to the local ordinance.
Yeah.
And as you know, you could stop people and detain them for
That's right.
traffic tickets and infractions and everything like that. So,
I remember that was an issue for a while where there was a recommendation or there was an order for everyone to wear a mask while they were out in public places, but no teeth or any mechanism for law enforcement to enforce that. And now, with you see all these videos of people who are in the grocery stores and refusing to put their masks on and then also refusing to leave. I think they actually ended up putting some teeth to that order and that mandate. Now, if we were having this conversation in Texas or Florida right now, we probably wouldn't be having the same discussion,
no.
but because I guess over there things are completely back to normal, but here we're still in the purple tier, and it's still important for everyone to be careful and to socially distance and everything like
Yeah,
that.
the cases have plateaued,
Yeah.
and I noticed over the past couple of days, maybe even risen slightly.
Yeah.
Nothing to be alarmed about, but it certainly isn't decreasing as quickly as it was.
Right.
You know, uh, but going back to my cop mentality, I always think about that.
Sure.
What a great way to stop and talk to people. Because they are violating the law. I
Mhm.
mean, the law says that you're supposed to have a mask, whether there's going to be real serious enforcement of that. But I'm sure that's worthy of a traffic ticket or a citation of some sort, I should say. And so, if you want to get stopped by the cops, just walk out there with your mask on because they're just looking
Right.
for a reason to talk to people, right?
I think the mentality is just kind of so backwards because people who have an issue with masks seem to think that some sort of kind of oppression upon them. But really, the mask is to protect other people from you. And it really goes to show how much you are considerate about others and how much
Mm.
you're being careful about their concerns. If you're of a position where you don't want to wear a mask, well, it doesn't really have to do with you. It has to do with people around you. So I would be in agreement that, it should be something that you should be stopped for and maybe talked about. I don't know if it should be something that you got thrown in jail for, but maybe a ticket I think might be. I mean, you get a ticket for crossing the street, not at a crosswalk or for speeding your car. It's kind of like the same thing. You're just not acting in anyone's safety.
Yeah, I don't like wearing the mask. I hate
Yeah.
it, in fact. But I do go along with what Joe Biden said: is it's your patriotic duty.
Right.
You have to understand that it's not that big of a deal. They ask you to protect other people.
Sure.
And I think about the World War II effort where everybody stopped what they were doing
Right.
and either enlisted, got into that war, or the people that were behind here went to the factories and they built and they worked, and it was just one large community pulling together. And all we're asking people to do is just wear the mask.
Greatest generation, right?
Right. Well, I'm not sure. We won't be calling our generation that, I don't think. How dare you?
Right,
So,
right.
So one of the things I wanted to talk to you about before we get into our case analysis today is you were recently married. Congratulations.
Thank you very much. Yeah, I'm officially married.
Yeah. So I had the pleasure, really, of watching the wedding via video because you were safe. You had a safe wedding. But it was wonderful. That video was incredible. I don't know. It wasn't Zoom.
Right.
It wasn't Skype. I don't know what in the world it was, but it was like you were right there.
When we were about maybe a month to a month and a half out, we were faced with a question of, number one, are we going to still do this wedding? And number two, if we are going to do this wedding, how are we going to try to include as many people into it as possible, while not having anybody feel left out? Because we cut down our guest list by about 75%. We decided to invest very heavily into a live streaming kind of platform, and the feedback we've been getting so far is that everybody was really happy with it. A lot of them felt like they were there, and our instructions to our videographer were basically, we really want people to feel like they're watching like a TV show of a couple getting married, so whatever you need to do that, and I feel like that effort was definitely worth it.
It did feel that way.
Yeah.
My daughter, I think I told you, is getting married, knock on wood, next year.
Right.
And maybe COVID will be done in 2022. But I think because we got family throughout the country, and stuff, and I would like to provide that anyways, because I think, a lot of times folks can't make it, but they would still like to see it,
Right.
And I felt that was really cool. You had your dogs in there.
Yeah, the dogs were a little bit difficult for them to walk down the aisle without a little bit of coercing, but they managed to make it. So, yeah.
That's pretty cool. Another thing about you is you recently were interviewed by the California Lawyers Association. Is that what it's called?
Yes.
Okay. So tell me about that association, because I'm an old timer. It used to just be the state bar, but now the state bar is just the enforcement mechanism. We really don't want to hear from them, but there's this association that you're a part of. What is it?
The California Lawyers Association is the former sections of the state bar. So on your bar registration, when you apply to a section membership, like say, for example, family law or solo firms or, litigation section, you are effectively signing up to be a member of the California Lawyers Association. Now, within the past couple of years, that's kind of changed a little bit because the California Lawyers Association is becoming its own independent entity, separate and apart from the state bar. But it still kind of works to try to provide a lot of value and services to attorneys. And the section that I'm specifically in, I'm the vice chair of the California Young Lawyers Association, which is the association that represents, or the section that represents, all new attorneys in the state of California under 5 years of practice or less. So our section specifically tries to provide practice skills, institutional knowledge, job skills, professional development, networking, although our networking meetings have kind of been put on hold for a little bit. But we hope to kind of get those things back in gear and really provide a lot of value to our members.
That's pretty cool.
Yeah.
I ever since I practiced, at least as a private practitioner, I've been, a member of like the family law section and a couple other things. And sometimes I've got great seminars. I just wonder, like, is the government still giving the association any money, or are dues going towards there, or what?
Yeah. So as of right now, when you pay dues towards your state bar section, the CLA receives those specific dues. Your state bar dues, if you don't register for a section, are 100% the state bar. So we don't get any of that. But if you do choose to become a member of a CLA section, then you get a lot of benefits. You get access to MCLE programming. You get access to our bank of webinars and platforms. I did a child custody webinar program last year that should still be up on the website. Very proud of that. And most recently, I was interviewed, like you said, for the CLA Diversity Project, which was it was an interesting opportunity to kind of talk about my background and and my experience as a attorney of color, and how that shaped my ability to become a family law attorney.
Yeah. Yeah, that was good. I thought that it was a very good interview. I learned something about you. I didn't know that you were really in college. You were thinking about getting a political career,
Yes, I
and
was.
then you took part of a campaign, or you worked for a politician, or tell me about that experience.
I actually, kind of, when I decided to step into the field of law, I did take a step back from my political aspirations. I do kind of get involved on a neighborhood level. I'm an active member of the Koreatown Neighborhood Council, so we work on things like street beautification, graffiti
Oh,
reduction, things
nice.
like that. Yeah,
Yeah.
and overall, just trying to make like the neighborhood a safer and more pleasant place to live. But I had the opportunity to work for a district court judge, and once I had the opportunity to see the legal side of things and the judicial side of things, I couldn't look back. I fell in love.
That's
Yeah.
kind of how my story was. I was a
Yeah.
police officer. I was in court. And I was watching these deputy DAs who will forever be my heroes, and
Yeah.
I'm like, man, I want to be like those guys.
Trial
know?
attorneys, right?
Yeah.
Trial attorneys who are very competent and skilled are really a sight to behold.
Yeah.
And it just makes you kind of just stand back in awe at their ability to kind of command the courtroom in that way.
Yeah, yeah. It's funny. I think a lot of lawyers maybe will think about running for office.
Mhm.
I supported a couple of campaigns. I've been involved in some things, and after a while, it's like, okay, I know I don't want to do that. One thing I don't want to do is spend 80% of my time raising money,
Right.
and stuff. When I had to participate in that, I thought, man, I like helping my friends, but
Right.
for me to be the one that has to call everybody and say, hey, can you give a little bit? That's a tough thing,
I think as a family law attorney, it's very instinctive to want to kind of go out and try to help as many people as possible, because that's basically what we do on a
Yeah.
daily basis. And the thought of kind of going into the political arena is very aligned with that idea that, let me do what I can to try to make people's lives better. But I feel like we do that every single day here.
We do.
And I'm very happy at the opportunity to be able to do that.
Yeah, yeah, we have a definite purpose, and that's to help people with their struggling problems, and try to help them as best as we can with the knowledge and skills that we have.
Exactly.
Yeah.
Exactly.
Okay, well, let's talk about this case.
All right.
I brought you in again because you are our man for many things, but definitely you love, the wonky part of attorney's fees and sanctions and stuff. So we're going to talk about a case. What's the name of this case?
This is Nancy Ernst and Michael Terhorst. It's a partially published opinion out of the First Appellate District. This one came out in January 11, 2021. The case was originally filed in Solano County.
Okay, so why don't you set up the facts?
Okay, so this is a wild one. I guess you could call it wild. These parties were trying to get a divorce for probably the better part of 9 years. 9 years is probably a good portion of someone's life to be spending in court and on attorney's fees. So just right off of the bat, this one was a contentious one.
So the longest one that I took part in, the woman came to me. She had been in it for 11 years.
Oh boy!
And we took another 2 years to finish. She'd been through like 4 or 5 attorneys.
Yeah.
Most people tell you never take a case where there's multiple attorneys. I just love this woman, and she was somewhat difficult to represent, but she listened to me, and we got her done.
There you go.
So about 11 years. So I got this one beat, but go ahead.
So in this one, it took a 3-day settlement conference before a judicial officer. Husband and wife and wife's attorney were in court, and they were arguing over the facts, and eventually they put their settlement agreement onto the record. So this is a common practice when we do settlement conferences. We don't have the time to run back to the office, type up a settlement agreement, so we'll just read the agreement into the record.
Okay, so I want to jump in on this.
Yeah.
So what people should know is that when you recite your agreement on the record, you're essentially reciting your contract with the other side.
Correct.
You're bound by that so long as the court does the proper waivers. Do you understand your rights? And they ask the parties that, have you had enough time to consult with your attorney? Okay,
Right.
This is going to be the order. Once that happens, it is an order.
Yes.
Right? Now, I would say this. It may be a common practice, it's not a commonly good practice. I've been burned a couple of times doing that because sometimes what happens is the record is vague.
Yes.
And what do you do after that? You got to prepare a judgment. And if you don't like the way that this judgment reflects upon what the real agreement was, then you're going to have to try to set aside that judgment and convince the court that there was a mistake. Sometimes the oral agreements don't have the minutia too.
Correct.
And the lack of detail could cause a lot of headaches later on. However, people do that, and that's what happened in this case, I guess.
Yes. So
Okay.
a headache is basically what has ensued as a result of reading their agreement to the record. The wife is not open about the fact that she has survivor benefits as a part of her federal employment retirement plan, and makes no mention of that during the settlement discussions. And
neither does he.
And neither does he. He claims he was not aware of it because it was never brought up. But the record shows that she had a private ex-parte conversation with the judge, which was okay. It was in agreement with both parties about the existence of those survivor benefits. So when husband goes and prepares the judgment and includes the division of the survivor benefits as a part of that, she says, no, that was not included as a part of our oral stipulated agreement in court. Therefore, I'm entitled to 100% of those benefits.
Okay, so let's stop and talk about survivor benefits. Neither one of us are quadro attorneys
No.
and experts on pensions, but I have read a few appellate court decisions through the years that deal with that issue. I was kind of surprised to find out that survivor benefits are community property.
Correct.
So, when people divide a retirement account, and sometimes I think that even if they don't, if the husband, for example, gets a retirement account and those survivor benefits aren't addressed,
Right.
they're still community property, and wife has them. And there's a couple of cases where wife number one is fighting wife number two over the right to those survivor benefits. I remember this one case, the guy had been married 3 or 4 times, and they had a couple of ex-wives, and they're fighting with each other. So this is just a case to remind us that does exist,
Yes.
that they're there. In this case, they didn't mention it in their oral agreement. Husband says, wait a minute, what about that? So he puts it in the judgment. Wife says, what?
Nope.
No.
I'm not going to sign that.
Because we had a meeting of the minds or something like that?
Because we had a meeting of the minds. It wasn't considered as a part of this agreement, and therefore there was no assignment of the rights for those survivor benefits. Now, the court took a very interesting approach to the appellate court.
Let's talk about the trial court first.
Trial court basically says the assignment of those benefits weren't assigned during the settlement, and therefore the court reserves jurisdiction as to any issues that were not addressed, or community property assets that were not
It's an omitted
divided.
asset?
Correct.
Okay.
And in its discretion, the trial court decides that the division of those survivor benefits should follow the division of the retirement plan. It's very kind of an intuitive way to divide that particular assets. Now, wife doesn't agree with that, obviously. She opposes husband's motion to try to have the survivor benefits divided, but the court rules against her and orders her to sign the settlement, the final judgment. She refuses. She doesn't do it, and husband has to file another motion to order her to sign it, in which case the court just basically signs it on her behalf.
Okay, so we've got a party who's not following the rules.
Correct.
Right? So the court says, this is divided. I want you to sign it. She doesn't sign it. In fact, didn't she file a motion to, for a new ruling or something,
Yes.
which was eventually
Dismissed. Right.
dismissed? Then the court says, "Now you will sign this."
Right.
She doesn't do that. So what is? And apparently they've been negotiating for a couple of months.
Right.
Where the husband's saying, "Yeah, you got to sign it."
So all of this stuff that's been happening after the settlement agreement adds an entire year onto the,
Oh my God.
into the case. So
And one other fact about this case, I think, that you got to talk about is who's the husband.
the husband is an attorney, but he's representing himself in this.
Okay,
case.
we'll talk more about that later on.
Yes.
Right. So eventually, what does he do? He throws up his hands, and what does he do?
Basically tells the court, Your Honor, I don't have any ability to get this case resolved pursuant to the court's orders. I'm asking the court enter the judgment, notwithstanding wife's objections, which the trial court does.
Yeah, and so, which I loved when I got into family law to know is that if there's a house that's sold and a spouse isn't signing over the deed,
Yep.
and they're not signing an agreement, guess what? you don't get to delay it anymore because you just have to go to court, and the
Right.
judge could order the clerk or the court clerk, or in this case they used some kind of a fancy name, but somebody signed it from the court, and boom, there's a judgment now,
Yes.
right?
So it's an interesting mechanism that the trial court uses to get this resolved. So wife is still not happy. She files a timely appeal saying that.
Wait, you're missing something.
Oh, I'm sorry. The trial court says, due to your conduct in frustrating the policy of the state to promote settlement of litigation and all the additional costs and time that was involved with your post-judgment motions or your after settlement conference motions, we award husband $800 in attorney's fees plus $180 in costs
Okay, as a sanction.
as a sanction.
So
Correct.
the court is turning and saying you're being sanctioned. You know,
Correct.
so reading this case, she deserved a sanction, didn't she?
Yeah, absolutely.
You know, because we expect people to follow orders,
Right.
Do what they're told to do, not clog up the system, not continue divorces 11 years.
Yes.
She didn't like the way things are. She was fighting City Hall, and her way of fighting was to not obey orders.
Yes.
So she deserved sanctions. There's no question about that.
Right.
But she didn't like the sanction.
She didn't like the sanctions. She didn't like the division of the survivor benefits.
So what did she do about it?
So she filed an appeal.
Okay.
Okay.
What was her argument on appeal?
Argument on appeal is number one, there was no meeting of the minds with respect to the issue of the survivor benefits, which the appellate court said, we're not persuaded with that. The trial court has jurisdiction to divide any remaining unadjudicated community property assets.
Right. So your contract theory is out the window.
Correct.
Okay.
Yeah. So no meeting of the minds there. The next argument is basically that there was no contemplation in the manner that the survivor benefits were to be divided. And this was a kind of an interesting take by the appellate court that I actually kind of made a little bit of an analogy. It's kind of like when the court awards a car to someone, but doesn't give them the keys to the car, right? The fact that the court awarded that car to that individual naturally invites certain things to go with that. So if the retirement plan is divided in a certain way, say it's 50%, well, it would seem to follow that the survivor benefits would also follow that
Part
type
and parcel of the
division.
retirement plan.
Exactly. So the court dealt with that issue, basically saying that the trial court's exercise of discretion in dividing that survivor benefit was proper. And then the most interesting part, I guess, of the case was with respect to the sanctions that were issued pursuant
What
to
happened there?
271. So this was a first case of first impression for the appellate court because they've never had to deal with the issue of a pro per party being awarded 271 attorney's fees. 271 is a family code section that awards fees in situations where someone has misbehaved or delayed and has caused the other party to incur attorney's fees.
So when you say this is a court of first impression,
Yeah.
what does that mean?
So basically, this is I meant a case of first impression, meaning that the appellate court's never dealt with this type of case before. It's the first time where a party has sought to overturn an award of 271 attorney's fees to a pro per party. Now, even though the pro per party is an attorney himself, the court said that his sanctions request was not tied to reasonable fees that he incurred. So it wasn't tied to the fact that he had to take time off work or that he lost business. It was just purely a punitive sanction that wasn't tied to any specific amount of fees that he incurred. Now,
Didn't the court also say something about the fact that the code itself
yes,
addresses attorney's fees,
correct,
and it followed some prior decisions that dealt with a slightly different issue, and that is whether pro pers can request attorney's fees. Can you discuss that a little bit?
Yeah. So when you file a motion for 271 sanctions, there are specific rules that we have to follow, and number one comes from a case of marriage of Keech. And the marriage of Keech says that in order to make a request for 271 sanctions, you need to provide a supporting declaration that shows that the sanctions are appropriate and they're tied to actual fees that you've incurred. So when we do our attorney's fees pursuant to marriage of Keech declarations, we say the amount of work that our office has performed, the knowledge, skill, and background and experience of the attorney who is arguing the case. And from that, the court has a set of information that it can rely upon to make that attorney fee order. In this case, there was no Keech declaration.
Because he was in pro per.
He was in pro per, right? So he didn't incur any fees representing himself. He didn't incur any costs. and there was no declaration that was
But
provided.
we're not
as to
talking
an
about
experience.
attorney's fees, counsel. We're talking about a sanction. So
Exactly.
how do you get over that? I mean, I'm just asking for sanctions. I'm not asking for attorney's fees.
Right. 271 specifically says that the attorney's fees are tied to the sanctions. And the reason for that is that it binds the court to sanctions awards that are limited exclusively to the amount of fees that a party incurs. In family law cases, we deal with very difficult opposing parties. We deal with very difficult opposing counsel. And it would be very easy for a trial court to basically say, I don't like the way that you're doing things. I'm going to sanction you $15,000, right? But 271 is written in a way that the trial court doesn't have that ability. You have to make the request. You have to show that you incurred costs as a result of that behavior. And then at that point, the trial court is only bound to the amount of fees and costs that you've actually incurred. So 271 is a very powerful section in the family code, but it's limited by the fact that you have to actually prove up your costs.
That's really, really interesting to me. I wonder if that code will ever be changed because of an outcome like this. Because like we said, this woman needed to be sanctioned. I mean, just sanction her $500 for crying out loud, but she got off scot-free.
Well, here's the interesting thing. Because, so we should probably say that the appellate court actually agreed with the wife in this and said that the award of sanctions to husband in the amount of $800 was improper based on the way that 271 is written. But this is an appeal. The costs and the amount of work and the briefing on appeals way exceeds $800.
Yeah.
And when you're the winning party on an appeal, you're entitled to your costs. But here's what I noted that was really interesting about this. Husband lost $800, but he probably spent a lot more pursuing this appeal and defending this appeal. So in a way, by having each side win one part of their argument, the appellate court said everybody bears their own costs on appeal.
You both lose.
They both lost. And that's the beauty of I guess I don't know if there's a beauty of this, but it's basically the turning point out of all of this is that no matter what you do, you always find some way to lose, even if you win on 2 out of the 3. So
in summary of this case, one of the points that I thought after I read it is the pro per. Okay, as attorneys, as salty old attorneys like me, we always say I'd rather have an attorney on the other side than a pro per. I mean, because they could be very difficult to get things done.
right.
Try to settle a case with somebody that has no legal knowledge, no sense of what the system is about, and that we're supposed to be working towards settlement.
Right.
Going to court, putting on a hearing with a pro per where the judge is giving them lots of leeway because they don't know what they're doing. Most of the time you're like, I would rather have an attorney on the other side because I think that in representing my client, I could get this thing done and probably get a pretty good result, and you're not going to get killed with, years of litigation, right? But this is one instance where if there's a pro per on the other side, even if that person's an attorney, your client could be misbehave, and there's no penalty for it.
What's the old saying? An attorney who has, attorney who represents himself has a fool for a client. Fool for a client, and husband really had a fool for a client this time around because not only did he work himself out of $800 in attorney's fees, he had to incur all the costs of an appeal as well.
Yeah.
So what I got as my takeaway from this case is if you are dealing with a person on the other side who is being extremely difficult, who is not cooperating, who is delaying the resolution of your case and incurring you additional costs, hire an attorney. Hire an attorney because that attorney will be able to put together a declaration saying, this is why the other side is delaying and increasing the cost of my clients. Therefore, we should be entitled to 271 attorney's fees.
And tell the other side, warn the other side with some teeth behind your warning that, look, if you don't do it, guess what? I will ask for contempt of court.
Yes.
There were some other remedies, I guess, that this attorney had. I mean,
Right.
He could have made a request for contempt. I don't know if there was a breach of fiduciary duty. I don't know about that because you're not really following. She wasn't failing to disclose anything or committing fraud. She just wasn't complying with the court orders.
I think what likely happened is what a lot of attorneys do is when they prepare a motion for entry of a settlement conference or a settlement agreement or a judgment, that they just add one more argument. And it's that one argument at the very end that comes back and bites you, right? In this case, I could totally envision that attorney, husband, finishing up his brief and saying, you know what, I want to put in a 271 request as well. And he does that, and that's the reason why he lost on that part of the
I'm
appeal.
going to speculate here because I don't know these parties.
Sure.
I don't live up there in Northern California or anything like that. But it was an 11-year litigation. He had some part of the craziness.
I'm sure.
You know what I mean? After a year or two of battling somebody that's not going along with the program, he could have pivoted and said, okay, we're getting a real attorney, a family law attorney, and that attorney is going to steer this thing to a conclusion because we can do that, right? We definitely could steer things to a conclusion. The only reason it goes 11 years is somebody doesn't know how to bring it to the finish line. Right.
Exactly.
Yeah.
And that's the kind of like the disappointing part is that they were at the finish line. They had a settlement agreement in hand.
But there wasn't enough blood.
There wasn't enough blood. And they had to squeeze that last bit of blood out of that stone, I guess. So
well, maybe we'll see some more appellate court decisions on this family. I mean, there are some decisions in California law that have the very same name, same parties, and there's part 1, part 2, part 3. Eventually, the appellate courts have fun with it. They go and they label them like that.
But what we know about cases like these is that they just don't end. They don't just kind of wipe their hands clean and walk away. When you see a set of facts like this where people have been litigating a case for 9, 10, 11 years, they'll find another way to get back into court. They'll find another way. So,
okay. All right, Anthony. This was great. This was a really good assessment of this case. Thank you for your discussion.
Absolutely. It was a lot of fun.
Okay. Congratulations again on your award.
Thank you.
Okay.